Hi, my name is Danielle with Northwest Registered Agent. I've been a corporate guide with the company for 5 years, and today we're going to be talking about the Pregnant Workers Fairness Act. This act affects all employers who have 15 plus workers, and under this act, all pregnant and postpartum full-time, part-time, temporary, and seasonal employees, as well as applicants of any gender identity, are protected. The employees or applicants must be able to perform the regular job duties outside of the time they are pregnant or postpartum. The Pregnant Workers Fairness Act is a law that requires employers to provide reasonable accommodations for workers experiencing physical or mental medical conditions caused by pregnancy or childbirth. Under PWFA, employers must provide accommodations to employees and job applicants who disclose pregnancy-related medical issues, unless the accommodation would create an undue hardship for the business. And we'll come back to what undue hardship is later. Employers cannot force an employee or applicant to accept a change to their work or environment. They cannot refuse an employee or applicant a job based on pregnancy. They cannot force employees to go on leave instead of making an accommodation, and they cannot retaliate against pregnant workers for requesting an accommodation. Now let's go over some key terms that are important to understand so you can understand this act. The first is undue hardship, which is a change to the work environment that would create substantial expenses or changes to the business. So if the accommodations you're asking for would cause undue hardship, they don't have to be granted by the employer. The next is interactive process. This is the conversation between the employer and the employee that will determine what changes need to be made. So those changes are called reasonable accommodations. Those are changes to the work environment or duties of the pregnant or postpartum employee that don't have a severe negative impact on the employer. Some examples of those accommodations might be time off for appointments and recovery, or flexible hours, or even postpartum needing a space for lactation. So how does an employee request an accommodation? To do that, they're going to notify their employer or HR of the accommodation, and then they're going to begin that interactive process and that conversation with the employer. You might be wondering what happens if the employer doesn't comply. In that case, the employee must give the employer 10 days notice before filing complaints or charges. And after those 10 days, they can file a lawsuit or a complaint with the U.S. Equal Employment Opportunity Commission. The last thing to note is that the complaint has to have taken place on or after June 27, 2023, when the act was put into effect. Thank you for tuning in. If you found this video helpful, give it a like and subscribe to our channel. If you have a topic you want us to cover, leave it in the comments below. And remember, call Northwest when you want more.